Hello everyone and welcome back to my channel. Now in today's video we're going to be talking about the types and formation of business organizations. We're going to be looking at sole proprietorship, partnership and company. And we'll also be looking at the body responsible for the regulation of um, the formation of a company and all that. So we're going to dive straight up into it. We know sole proprietorship is a one-man business, and it's solely owned by one person. You get. So it doesn't have to do with it doesn't have much to do with the Corporate Affairs Commission, as he can carry on business in his surname without any regulation. So the major focus for today is going to be on partnership and company. Now we understand that partnership is an association of at least two persons, yeah, to 20 persons, 2 to 20 persons, for the purpose of business, profit making, and profit sharing. So keep that in mind. Um, okay, so more or less, we actually need to be abreast of the fact that there are some legal relationship that we should know, that they are not. It's not every partnership, or it's not every thing that we should consider as partnership. There are times when we get involved in some business and we think of it as partnership. So there are some guidelines according to the Partnership Act in Section 2 Sub 3 that we should know that does not mean partnership. So the Act spelled out that a receipt by a person of a debt or other liquidated amount by installment or otherwise out of the accruing profit of a business is not regarded as partnership. So we're just, for instance, the when a person is paid of a debt or maybe any other amount by installment out of the profit of a business, it is not regarded as partnership. Also, when we pay salaries to employees, it's not regarded as partnership. So even though it's from the profit of the business, when also we give out annuity to the widow or to the child of a deceased partner, in which that partner was the deceased partner was part of the business before he died, it is not still regarded as partnership, even though the money is coming out from the profits of the business. Also, when we also pay annuity from the portion of a business, maybe in consideration of a sale by a person of the goodwill of a particular business. Let's say, for instance, we give out annuity from the profit of a business because of someone made a sale, because of his goodwill. Now, that is not partnership. And that is joint tenancy, tenancy in common, or part ownership of property, or common ownership of property. Whether tenants or owners do not share any profit made by the use of the company, it is not still regarded as partnership. So, more or less, there are different type of partnership. We have general partnership, and also we have limited partnership. Now, under general partnership, we just made to understand that this is that kind of partnership where all partners are involved in the management of the partnership business. So let's dive straight up to the formation of partnership. How can partnership be formed? So naturally, it can be formed by agreement, expressly or impliedly. What I mean to say is it can actually be formed by an agreement, whether with words or written under seal. So and then there is something we call partnership deed. Partnership deed is that partnership deed is like a formal arrangement under seal that contains the terms of the partnership. It spells out the facts, the content of that partnership. So the partnership deed highlights the name of the partnership, the parties to the partnership, the nature of the partnership business, the rights of the and duties of the partners, the mode of admission of new partners. That is how do they get new partners, the retirement of partners, the partners, the partnership assets, the accounts and audits, and also the how the partnership will get dissolved over time. So this is what it is contained in the partnership deed. But we should also keep in mind that in as much as we mentioned that a partnership membership has to do with 2 to 20 persons, there are some exceptions. Like a cooperative society duly registered in Nigeria, is exempted. It can still be a legal partnership we also have people practicing law, and also the accounting, qualified accountants practicing their profession. Yeah, when we have these three in place, there is an exception to the membership of 2 to 20, right? So we let us just talk about the the let's say the duties or the obligations of partners. Yeah, the obligations of partners in a partnership business. Um, First off, would need to note that all partners are entitled to share equally in the profits of the business and also the loss. So whereas if there is a case where the business made a loss, yeah, if where the business made a loss, we should note that the partners have we borne that loss. So there was a case here between Chideak and Laguda, yeah, in 1954, whereas they appointed a managing director and vested upon him the full powers to take up the administration of the business. Now, during that time, the firm incurred a lot of debt, and the partners blamed it all on the managing director. Yeah. So when they went to court, the Supreme Court held that so far they cannot prove of an allegation of misappropriation of fund, yeah, the partners will bear the liability which was allegedly caused by the managing director. So you see in this case now, it's not just in the sharing of profit, also in the bearing of losses, they will also bear in it. Yeah, whether or not is a managing director to it, it doesn't concern the court. So far you cannot provide a valid proof, it won't stand, and the partners will bear the loss. Also, there is also an obligation that the firm must indemnify, that is, compensate every partner in respect of the payment made or personal liability incurred by him. Let's say you're carrying out a business as a partner, and let's say you spend some amount of money in the course of running that business. You shall be indemnified according to what this rule is stating in section 24 of the Partnership Act. Also, we also need to understand that every partner may take part in the management of the business. Yeah, every partner may take part in the management of the business. You get, so, and you cannot actually introduce a partner without the consent of the existing partner. So these are different obligations, rights, and relationships of partners. Um, Now let's talk about how general partnership can be dissolved. How general partnership can be dissolved. First is the expiration or notice. You can actually dissolve a general partnership by way of notice. Let's say, for instance, you fix the partnership for a set period of time, say 1 year, and then we've reached that 1 year and you just want to call it quits. Now, you can actually dissolve partnership by that way. It's like an agreement between the partners. Also, bankruptcy or death of a partner can actually lead to a dissolution. Another thing is illegality can lead to dissolution. Yeah, when it's unlawful for business to carry out to be carried out by its members, then it can be dissolved. Okay, there are other ways by which a partnership can be dissolved. Let's say one of the partners go to apply to the court for that dissolution. Then we'll find out that the court may decree based on the fact that, let's say they find out that one of the partner is a lunatic. Yeah. Or also the person that is other than the person that is suing, yeah, one of the partner in a way is not capable of performing his duties. Yeah, when he's not capable of performing his duties, you find out that the court can decree a dissolution of that partnership business. And also, if he's guilty of a conduct calculated to affect the business, yeah, when he do something, he's guilty of the fact that it is something he has done that will affect the carrying on of that business, that you know that the partnership there can be dissolved. Yeah. Also, if there's a breach of the partnership agreement, let's say one partner breached the partnership agreement, then there is a problem there and the partnership can be dissolved. um and also when the business is run at a loss, rightly speaking, it can be dissolved. So there are Yeah. There are ways when there are ways of settling accounts. Let's say, for instance, the partnership wants to dissolve and they need to disburse their debt, like they need to pay off debts and liabilities subject to agreement. There are ways they actually do it. They put it in this order. Um, the first of all, they share, they pay out their debt from the profits, yeah, from the capital, and also individually contributions. Yeah, these are ways they give it out. They give their loans, and so it's like what is said. They say, aside from this, these assets, including any sums contributed by the partner to make up the losses or deficiencies of capital, are applied in the following way. Parents paying the debt and liabilities of the firms to persons who are not partners. So they'll first pay the debt and liabilities of the firms to people who are not partners. They also pay liabilities and debts of the firm to people who are partners. So this is the hierarchy now, and they will also pay proportionately what is due to him in respect of the capital, and then the ultimate residue. So it's more or less like saying that they'll first pay those that are outside before they now settle those that are inside. Yeah. So again, we should know that partners act as agents to other partners. A partner acts as agent to other partners, and he is obliged to do all, yeah, and act on behalf of the firm, on behalf of the firm and the partner. So another thing is he renders true accounts and full information of anything to the partner. Anything affecting the partnership, he renders true accounts and full information about it to the other partners. So, and it does not make secret profit. You get, and lastly, it does not compete with the firm. So these are um the 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 stuffs to it. And like I said, there's also something called limited partnership. Under limited partnership, we find out that we could have people who don't want to be involved in the management of the company, or sorry, the partnership, but wants to be a financial contributor to the business. Now, this is where limited partnership comes to play. This is where it comes to play. Now, there are features to it. There are features to it. Let's say a limited partner is only liable to the extent of his contribution. So let's say, for instance, the business ran at a loss or have liabilities to settle. Yeah, when they're actually paying it out, they would only, like the limited partner will only be liable to the amount he contributed, while the other general partner bear the full burden without limitations on that liability. So limited partnership, for instance, also consists of one or more general partners, and then we could have other limited partners. Okay, and we're meant to understand that a limited partner cannot bind the firm because of the fact that he's not partaking in the day-to-day activities of the business, he's not partaking in the management of the business. He cannot come and bind the firm. Yeah. Also, we know that a limited partner's death does not affect the business. It cannot dissolve the business. It's when a general partner dies, that's when it can affect the business. And also, even if it comes to give a notice, just like we've mentioned outrightly, that expiration or notice can actually dissolve a partnership and other things, including bankruptcy, charge, or illegality. Well, when it is from a limited partner, it doesn't stand. Yeah, there's an exception to it, doesn't stand. So let us look at limited liability partnership. Yeah, this was first introduced in Lagos in 2009, but then it extended to other states as time goes on. Now, under it, we'll be looking at the documents for incorporation. We need to understand that before you actually incorporate a partnership business, um, you must fill in form which states the name of the partnership, the general business of the partnership, the parties, sorry, the registered office, I mean to say, the partners, then there is name and address of each partners, and also the name and address of designated partners on incorporation, and then any other information on the business which may be required by the CAC. Yeah, so we're looking at the nature of limited liability partnership. Um, One good thing about limited liability partnership is on the fact that it has this element of corporate personality, in that it is separate from that of the owner. It also has perpetual succession, but we should know that it's given on the fact that a limited partner itself cannot actually um, close down the business. Hence, it's a perpetual succession in that a change in membership does not affect the existence of the business. Now, it must actually have two partners and two designated partners. Yeah. It can be sued or it can sue or be sued in its name. Yeah, it has a common seal. You can have a common seal if it wish. Okay, it can actually own property in its name. These are the nature of limited partnership. Yeah. Okay, so more or less this designated partner is looking to me like a general partner because it's responsible to do all acts, matters and things that the karma may require, which include the filing of documents, of any document return, statement and other reports. Yeah, so and is liable to open penalties that may be imposed by the act. So more or less looking like a general partner in this regard. Now, you need to understand that when you want to carry on the name and publication of limited liability name, you affix the word LLP to your invoice, yeah, trademark, logo, like you always affix your the name, the registered address, registration number to your invoice, correspondences, publications, and all that. Now, let us dive straight into um, cessation of limited liability partnership membership. So, when will you say a partner may cease to be a member of a limited liability um, partnership? So, okay, on the person's death is number one. On the dissolution of partnership is number two. And when he is declared to be of unsound mind, yeah, and also if after applying to be caught, yeah. So these are when a limited partnership can cease to, like when a person can cease to be a member of limited partnership, because we said before that a change in partnership does not actually cause or affect the business, yeah, from carrying on. So these are ways that okay, can say a person ceases to be a member of limited partnership if he dies, or the business stops, or is of unsound mind. You get, so these are the it. So now when a limited partnership is dissolved, what are the entitlements, yeah, of a partner, of limited liability partner? So again, remember, limited partner is only liable to the amount he contributed. So that actual contribution, first off, is his gain. Then if there are profits, accumulated profits, and he stands to benefit from it. And if there are loss, he will also pay for it. So um that is okay, as mentioned, the entitlement of limited liability partner. So are there limits to the liability of the partnership? Yes, there are limits. So the partners the partner lacks the authority to act for the partnership. Like I said, you cannot bind the firm. You can't bind the firm. You are a limited partner, only entitled to what you contributed. You are not involved in management of the business, so you cannot bind the firm. Okay, so they say if the third party is aware of the lack of authority or does not know or believe that he is a partner in the limited partnership, there is a limit. So there's a limit if the third party is aware that you do not have authority, even if he does not know that you're a partner. You have a limit there. Mm-hmm. So you can read up the remaining parts to be abreast of what it's saying right there. Okay. Now, maintenance of accounts and other records. Yeah, so you have to follow the system of accrual based or cash based um system, cash based system. That I follow that. Yeah. Mm-hmm. Okay. So it is mandatory for a limited partnership to file annual report with the CSC 60 days after the closure of the financial year. Okay, so there are times when the corporate affair may choose to investigate on the affairs of the limited liability partner. And what are those times? Okay, let's say 1/5 of the members apply for it, or the firm apply for it itself, or in the opinion of the CAC, they just feel that there's an intent of fraud, like intent to defraud the creditors, yeah, or some unlawful or fraudulent activities going on, so they might choose to investigate on the partnership. So let's move on to the winding up and dissolution of limited liability partner. Then we talked about how a member can cease to be a part of limited liability partnership. Now let's look at the winding up and dissolution. Can we say, or when can we, what can we see and say, okay, fine, this are ways to dissolve limited liability partnership. Okay, first is when the partners themselves decide or agree to close. Yeah, so there's a notice between amongst themselves to close down the partnership, or the number of persons fall below 2. Yeah, remember the membership, this thing fall below 2, or the business is unable to pay its debt. It's another way the business is unable to pay its debt. If it does, the business will be wounded up. Okay, and next is the court's opinion is just and equitable that it should be wound up. So these are ways that a business can actually wind up. So we'll stop here for now, and then the next video we'll be talking about registration of a business name, and then we'll move on straight to company. Thank you so much. Please subscribe, like, and turn on the notification bell to flow with my channel. Thank you so much.